Before we dive in, it is absolutely critical to understand that this video is for informational purposes only and does not constitute legal advice. I am not your lawyer. The law varies dramatically by state and the specific facts of your situation. If you need legal assistance, you must consult with a qualified attorney licensed in your area. Think of this presentation as a driver's ed class for your constitutional rights. It's here to educate you on the rules of the road, not to drive the car for you. The knock on the office door is polite, almost friendly. Mark, a mid-level project manager, looks up from his spreadsheet to see two men in plain clothes. They don't look like cops from a movie. They look like dads who might coach Little League. One smiles. Mark Jensen? We're detectives Miller and Diaz. Got a minute? We just have a few questions, hoping you could help us clear something up. Mark's heart does a little tap dance against his ribs, but his mind is racing with innocent thoughts. Asterisk, clear something up? Of course. I'm a good citizen. A helpful guy. Asterisk, sure, he says, gesturing to the two chairs in front of his desk. What's this about? Just a routine follow-up, Detective Miller says, his voice calm and reassuring. There was an incident in your neighborhood a few weeks back. A robbery. We're just talking to everyone in the area, dotting our I's and crossing our T's. You're not in any trouble, we just want to see what you might remember. Relief washes over Mark. Asterisk, go, the robbery down the street. I have nothing to do with that. Asterisk, he leans back, ready to help. He wants to be helpful. He tells them about his day, where he was, who he was with. He answers every question honestly. He has nothing to hide. The detectives nod, they listen, they make him feel like he's part of the team, a key player in solving the case. The conversation is casual, almost like chatting with new neighbors. But then the questions start to shift. Slowly, subtly. You said you got home around 6 p.m., right? That's interesting. A neighbor's security camera shows your car turning onto the street at 6:22 p.m. Can you explain that? Mark hesitates. Did he stop for gas? He thinks so. Yeah, I think I stopped for gas. Which station? Detective Diaz asks, not looking up from his notepad. The Shell on Elm? Mark says, but it comes out like a question. He's not sure. His memory is fuzzy. There is no Shell on Elm, Mark. The temperature in the room seems to drop 10 degrees. The friendly chat is gone. The questions get more pointed, more specific. They ask about his finances. They ask about a jacket he owns. They twist his words. The 22 minutes he can't perfectly account for become a black hole that they keep pointing to. Mark's desire to be helpful has now painted him into a corner. Every correction he makes sounds like a lie. Every fuzzy detail sounds like an evasion. And that's when Mark realizes the friendly chat wasn't friendly at all. The office door is closed. He is no longer a helpful citizen. He is a suspect. That feeling in Mark's stomach? That cold, dropping sensation of a trap closing? That is a moment millions of Americans, most of them completely innocent, face every year. And in that moment, everything you think you know about justice, fairness, and the police is wrong. Your natural human instincts will betray you. Your desire to cooperate, your belief that the truth will set you free. Your fear of looking guilty by staying quiet. These are the very tools that will be used to build a cage around you. We've all heard the phrase on TV, lawyer up. It's a line from a movie, something a tough guy screams before he's dragged away. But what does it actually mean for a regular person like Mark? What are the magic words? What happens in the real world 1 minute after you say them? What happens 1 hour after? This is your definitive guide. We are going to strip away the Hollywood fiction and give you a practical step-by-step playbook for navigating one of the most high-stakes situations a person can face in the United States. By the end of this presentation, you will understand not just why you should invoke your rights, but how to do it, when to do it, and exactly what legal machinery grinds into motion the second you do. You will learn the single most powerful phrase you can say to law enforcement, why staying silent is a sign of intelligence, not guilt, and how the entire game changes the instant you put a lawyer between you and them. It all begins with a handful of words written over 200 years ago, in the Fifth Amendment to the United States Constitution. No person shall be compelled in any criminal case to be a witness against himself. Think about that word. Compelled. The founders of the country had just escaped a system where the government could drag you into a dark room, torture you, and force you to confess to anything they wanted. They understood that the most dangerous power a government can have is the power to use your own mind, your own words against you. So they built a wall. They declared that your thoughts, your memories, your knowledge, they are your private property. The Fifth Amendment posts a constitutional, no trespassing sign on the door to your mind. The government cannot force its way in. But here's the catch they don't teach you in school. They don't have to force their way in if you willingly open the door and invite them in for coffee. This leads us to the single most dangerous misconception in the American legal system, the one that trapped our friend Mark. The idea that if you are innocent, you have nothing to fear from talking to the police. If I just explain everything, the thinking goes, they'll see I'm innocent and leave me alone. If I stay quiet, I'll look guilty. This is catastrophically wrong. And here's why. First, you have no idea what they know. The police may have bad information. An eyewitness might have mistakenly identified you. A piece of evidence might falsely point in your direction. When you start talking, you are walking through a minefield blindfolded. You might say something you believe is completely innocent that directly contradicts the bad information they have. And in their eyes, you've just gone from a helpful witness to a liar. And once they think you're a liar, they start to believe you're guilty. Second, human memory is horribly unreliable. Can you tell me with 100% certainty what you were doing at 2:15 p.m. last Tuesday? Can you recall every stop you made on your way home from work 3 weeks ago? Of course not. But when you're in a high-stress interview, you'll try. And you might get a detail wrong. You might say you turned left when you turned right. You might say you spoke to your boss before lunch when it was after. To you, it's a meaningless slip. To a detective building a case, it's an inconsistency. It's a crack in your story. It's another reason to believe you're lying. Third, and this is the most important, police officers are allowed to lie to you. It's a standard, legally approved interrogation technique. They can tell you your buddy in the other room already confessed and blamed you. They can tell you they have your fingerprints on the weapon even if they don't. They can tell you they have a video of you at the scene. They can tell you that if you just confess, they'll make sure the judge goes easy on you. A promise they have absolutely no power to keep. Their job is not to find the truth. Their job is to close the case, and the easiest way to do that is to get a confession. They are professionals trained in psychological tactics designed to get you to talk. You are an amateur. You will lose. Finally, remember the famous Miranda warning. Anything you say can and will be used against you in a court of law. It doesn't say anything you say can be used for or against you. It is a one-way street. Any statement you make that helps prove your innocence is often dismissed by police and prosecutors as self-serving. But any tiny thing you say that helps their case, that makes you look even a little bit guilty, will be treated as an undeniable confession, recorded, transcribed, and used to destroy your life. This is why the first rule, the foundational rule that every single defense attorney in America will tell you, is to shut your mouth. The right to remain silent isn't for the guilty. It's for the smart. It's for the person who understands that they are in a dangerous situation where their words can only harm them. Now, you've seen the Miranda warning on TV 1,000 times. You have the right to remain silent. You have the right to an attorney. But most people don't realize that the police only have to read you that warning under very specific circumstances, when you are in custody and you are being interrogated. And those two words, custody and interrogation, don't mean what you think they mean. Custody isn't just when you're in handcuffs in the back of a squad car. The legal test is, would a reasonable person in your situation feel free to terminate the interview and leave? If the detectives ask you to come down to the station, and they put you in a small windowless room and close the door, are you really free to leave? If they show up at your job like they did with Mark, are you truly comfortable telling them to get lost? In many cases, the answer is no. You are in custody. And interrogation isn't just a rapid-fire series of questions under a hot lamp. The legal standard is any words or actions on the part of the police that they should know are reasonably likely to elicit an incriminating response from you. A detective sadly shaking his head and saying, "I just wish you'd tell me why you did it, your family deserves to know," is a form of interrogation. So you have this fundamental right to remain silent. But just sitting there silently isn't enough. In fact, under a controversial Supreme Court ruling, in some situations before you're arrested, your silence can be used against you as evidence of guilt. To protect yourself, you can't just be silent. You have to actively, verbally claim your right. You have to invoke it. And that brings us to the second and arguably more powerful shield you have. It's the one that stops the game entirely. It's the one that forces the detectives to stop talking, to pack up their notebooks, and to leave you alone. It is your right to an attorney. This isn't just a line from a movie. It's a constitutional sledgehammer. The right to an attorney, enshrined in the Sixth Amendment and made famous by the 1966 Supreme Court case Miranda versus Arizona, is fundamentally different from your right to remain silent. Silence is a passive defense. It's you alone building a wall of quiet. But invoking your right to an attorney is an active, offensive move. It's not just you putting up a shield. It's you summoning a gladiator to fight for you. It's you telling the state, with all its power and resources, that you will not face them alone. But here's the critical multi-million-dollar detail that so many people get wrong, often with devastating consequences. You have to be crystal clear, unambiguous, absolute. The law does not protect maybes. It does not protect hints or suggestions. Police are specifically trained to identify and exploit any ambiguity in your request for a lawyer. Saying something like, "Maybe I should talk to a lawyer," is not enough. Asking, "Do you think I need an attorney?" is not enough. Even a statement like, "I think I want a lawyer," has been found by courts to be too wishy-washy. These are seen as mere musings, not a legal invocation. To the trained ear of a detective, those phrases are a green light to keep pushing, to keep questioning, because you haven't pulled the emergency brake. You've only commented on how shiny the brake handle looks. The magic words are simple and direct. "I want a lawyer. I am invoking my right to an attorney. I will not answer any more questions until I have a lawyer present." There is no room for interpretation in those sentences. They are declarative. They are final. This isn't just legal theory. This is a reality forged in the highest court of the land. Consider the case of Davis versus United States. In 1994, a sailor named Robert Davis was being questioned by Naval Investigative Service agents in connection with a murder. Initially, Davis waived his Miranda rights and agreed to talk. About an hour and a half into the interrogation, the pressure mounting, he said, "Maybe I should talk to a lawyer." The agents didn't stop. They didn't get him a lawyer. Instead, they responded by saying they didn't want to violate his rights and asked him to clarify. Did he want a lawyer? Or was he just making a comment? Davis, likely feeling the pressure to not seem uncooperative, eventually said, "No, I'm not asking for a lawyer." He then continued to talk and made incriminating statements that were used to convict him of murder. His case went all the way to the Supreme Court. And what did they decide? They decided that his statement, "Maybe I should talk to a lawyer," was not a clear and unambiguous request for counsel. Therefore, the agents were not required to stop the interrogation. The court placed the burden squarely on the suspect to be direct. Justice Sandra Day O'Connor wrote that if a suspect makes an ambiguous or equivocal statement, police are not required to stop questioning. Think about the catastrophic weight of that one word. Maybe. That single word cost Robert Davis his freedom. It's a chilling lesson in the power of language inside an interrogation room. The police are not your friends. They are not there to help you interpret your rights in the most favorable way. Their job is to close a case, and if your hesitation allows them to keep the door open for questioning, they will walk right through it. So, what happens when you do it right? What happens when you look the detective in the eye and say with absolute clarity, "I want a lawyer"? Everything stops. It's like saying a safe word in a high-stakes psychological play. The interrogation must cease immediately. Period. They cannot ask you another question about the crime. They can't ask, "Are you sure?" They can't say, "Come on, just a few more questions, we're almost done." They can't try to persuade you that asking for a lawyer makes you look guilty. The moment you make that clear request, the conversation is over. Any evidence they gain by ignoring your request will almost certainly be thrown out of court. Let's imagine it. You're in that small windowless room. Two detectives are in front of you. They're using all the classic techniques. One is friendly and understanding, the other is stern and impatient. The old good cop, bad cop routine. They're suggesting they have evidence they don't, maybe bluffing about a witness or a fingerprint. They're trying to build a rapport, make you feel like talking is the only way to help yourself. The pressure is immense. Your heart is pounding. You're trying to remember every detail of the last 48 hours, terrified you'll say something that sounds wrong. In that moment, you have a choice. You can play their game, a game you are not equipped to win. You can try to talk your way out of it, risking that one slip of the tongue, one misremembered fact, one nervous contradiction that they will later frame as a consciousness of guilt. Or you can end the game. You take a breath. You look at them both. And you say, "I am invoking my right to counsel. I will not answer any questions without a lawyer." Watch what happens. The friendly demeanor will likely vanish. The notepad might be closed with a little more force. the offer of a coffee is rescinded. The entire atmosphere in the room will shift from one of feigned cooperation to one of frustrated bureaucracy. And that is a beautiful thing, because that shift in atmosphere is the physical manifestation of a massive power transfer. The power has just moved from them to you. You have taken control of the situation using the tools the Constitution has given you. They now have to play by your rules. They can no longer speak to you. They must go through your attorney, your professional trained gladiator who knows the arena far better than you do. Invoking your right to an attorney is not an admission of guilt. Let me repeat that, because it is one of the most pervasive and dangerous myths in the American legal system. Invoking your right to an attorney is an admission of intelligence. It's an acknowledgement that you are in a serious situation, a situation with its own complex rules and language, and you require a professional translator and advocate. A pilot doesn't perform his own heart surgery. A heart surgeon doesn't fly a 747. When you are in the legal arena, you call a legal expert. It is the single smartest thing you can do, because once you say the magic words, you've rebalanced the scales of justice. The state, with its investigators, its prosecutors, and its vast resources, is on one side. And on the other side is no longer just you, alone and intimidated in a small room. It's you and your counsel, and that changes everything. But knowing your rights is only half the battle. Police officers and detectives have a whole playbook of psychological tactics designed to get you to willingly give up these rights. They are masters of persuasion, trained to create an environment where waiving your rights feels like the natural, easy, and even the right thing to do. So, what are these tactics? How can you spot them, and more importantly, how can you resist them when the pressure is on? Let's start with one of the oldest tricks in the book. One you've seen 100 times in movies. Good cop, bad cop. It's a cliché for a reason, it works. Here's the setup. One detective comes in hot. They're aggressive, accusatory, maybe they slam a file on the table. They'll say things like, "We know you did it. We have witnesses. You're looking at 20 years, and I'm going to make sure you get every single day." This officer is designed to create fear, anxiety, and a sense of hopelessness. Your heart rate skyrockets. Your palms get sweaty. You feel trapped. Then after a while they storm out, maybe kicking a chair on their way. And in comes the good cop. They might offer you a water or a coffee. They'll sit down, lean forward, and speak in a calm, understanding voice. "Look, my partner," he gets a little carried away. He's convinced you're a hardened criminal. "But me? I don't see it. I think you're just a regular person who got caught in a bad situation. I think there's another side to this story, and I want to hear it. Just talk to me. Help me help you. I can talk to the DA, maybe get this whole thing reduced. But I can't do anything unless you work with me." The psychological trap is brilliant. The bad cop creates a storm, and the good cop offers you an umbrella. Your brain, desperate to escape the stress and fear, latches onto the good cop as a savior. You see them as your ally, your one hope in a hopeless situation. But you have to understand this. They are not two opposing forces. They are a team. They walked into that station together, they probably had coffee that morning, and they are both working towards the exact same goal, getting you to confess. The good cop is not your friend. They are simply the more effective tool of persuasion in that moment. A second, and perhaps more insidious, tactic is called minimization. This is where the interrogator downplays the moral and legal seriousness of what you're being accused of. They reframe the crime not as a malicious act, but as an understandable mistake. Let's say you're being questioned about an embezzlement case. The detective won't say, "Did you steal thousands of dollars from your employer?" betraying their trust. Instead, they'll say something like, "Listen, we know things are tough. The economy is terrible, bills are piling up. I bet the company wasn't paying you what you were worth anyway, right? A guy like you with a family to support, you did what you had to do. It wasn't about greed, it was about survival." A lot of good people would have done the same thing in your shoes. This was just a mistake, a temporary lapse in judgment, not a reflection of who you are. See what they're doing? They're giving you a moral excuse. They're building a bridge for you to walk across, from denial to confession. It feels less like admitting to a felony, and more like explaining a difficult choice. They make it sound like the consequences won't be that severe because the act itself wasn't that bad. It's a powerful technique because it taps into our deep-seated desire to be seen as a good person who just made a mistake. By agreeing with their minimized version of events, you are, in fact, confessing to the crime. Once you've admitted to the minimized version, the legal system takes over. And that context they offered you, the understanding and justification, it vanishes. All that's left is your confession, which will be presented in court in the harshest light possible. Now, let's talk about the elephant in the room when it comes to interrogation, the Reid technique. This is a 9-step system of interrogation that has been the gold standard in American law enforcement for decades, and it is designed from start to finish to make an innocent person feel guilty and a guilty person feel hopeless. One of its most powerful and shocking components is the authorized use of deception. Let me be crystal clear about this because most citizens do not know it. The police are legally allowed to lie to you during an interrogation. This isn't a gray area. It was upheld by the Supreme Court in the 1969 case Frazier v. Cupp. They can lie about evidence. They can lie about witnesses. They can lie about what other people have said. So you're sitting in that room determined to stay silent. The detective might lean back and say with complete confidence, "Well, it doesn't really matter if you talk to us or not. We found your fingerprints all over the weapon. Your DNA came back a match from the lab this morning. And we have 2 eyewitnesses who picked you out of a lineup. So we're not here to ask you if you did it. We're past that. We're here to understand why you did it." That's what the judge and jury will care about. Were you acting in cold blood? Or was there a reason? Because right now, without your side of the story, it just looks bad. It looks like the work of a monster. Every single word of that can be a complete fabrication. There are no fingerprints. There is no DNA match. There are no eyewitnesses. But they are telling you this to create an overwhelming sense of inevitability. They are painting a picture where your conviction is already a foregone conclusion. Your silence in this context no longer feels like a shield. Feels like a liability. It feels like you're giving up your only chance to frame the narrative, to explain yourself, to mitigate the inevitable punishment. Your resolve to stay silent evaporates because what's the point if they've already got you dead to rights? This tactic is brutally effective at getting people to abandon their Miranda rights and start talking, desperate to dig themselves out of a hole that, until that moment, didn't even exist. Finally, there's the simple, disarming power of rapport. This isn't about aggression or deception. It's about making you feel comfortable. It's about exploiting the basic human need for connection in a moment of extreme isolation and stress. The interrogator might come in and not even mention the case for the first 20 minutes. They'll see a tattoo of your favorite sports team and talk about last night's game. They'll find out you're from the same part of the state and reminisce about a local restaurant. They'll talk about their own kids, their own struggles. They offer you food, they let you smoke. They listen. They nod. They validate your feelings. They are becoming your friend. And in the sterile, intimidating environment of an interrogation room, that feeling of connection can be like a drug. You start to let your guard down. You stop seeing them as an adversary, as an agent of the state whose job is to build a case against you. You start seeing them as just another person, a reasonable guy who is just trying to do his job. And you want to help him. So you start talking. Maybe not a full confession at first. You just fill in a few small details. You clarify your timeline. You explain a minor inconsistency. You think you're just having a conversation. But you're not. You are in a custodial interrogation, and every single word you say is being noted, recorded, and analyzed for its potential to be used against you in a court of law. That friendly conversation is, in reality, the meticulous construction of a cage, and you are handing them the bars one sentence at a time. All of these tactics, the intimidation, the minimization, the lies, the false friendship, are designed to do one thing: to short-circuit your rational brain and appeal to your emotional, instinctual brain. They create a psychological landscape where staying silent feels counterintuitive, dangerous, and socially unacceptable, while talking feels safe, productive, and like the only logical path forward. So there you are. You're in that room. The walls are closing in. You feel the immense pressure to just explain. You know you have the right to remain silent, but how, in the face of all this psychological warfare, do you actually exercise it? What are the precise words you need to say? Because invoking your rights isn't like in the movies. Saying it the wrong way, or saying it too weakly, can lead to police legally ignoring you and continuing their interrogation. What is the bulletproof phrase that stops everything in its tracks? The answer is devastatingly simple, yet so many people get it wrong in the one moment it matters most. The courts have a standard for this. Your request for a lawyer must be unambiguous and unequivocal. That's fancy legal talk for crystal clear. There can be no doubt, no hesitation, no room for interpretation in what you are saying. You can't hint at it. You can't ask if it's a good idea. You have to demand it. Think about that. In a moment where you are terrified, confused, and your adrenaline is surging, The legal system requires you to have the presence of mind to speak with absolute, unwavering clarity. It's a brutal standard and it has destroyed people. Take the case of Warren DeMezum in Louisiana. In 2017, a video of his interrogation went viral. He's sitting in a room with detectives and he says this quote, "If y'all, this is how I feel if I'm thinking I'm going to be charged with anything, I want to talk to a lawyer." Now to you and me that sounds pretty clear. The words, "I want to talk to a lawyer," are right there. But the Louisiana Supreme Court disagreed. They seized on one word. The very first word he said, "if." Because he said, "if," the court ruled his request was conditional. It was hypothetical. He was saying he wanted a lawyer if he was going to be charged. The court decided that since the detectives hadn't decided to charge him at that exact moment, his request for a lawyer didn't count. It wasn't unequivocal. So, they were legally allowed to continue the interrogation, which they did. This isn't some bizarre one-off ruling. This is based on a major United States Supreme Court precedent, a case called Davis v. United States from 1994. This is the case that sets the standard, and the story is chilling. A sailor in the U.S. Navy was found beaten to death with a pool cue. Naval investigators, the old NIS, what is now NCIS, zeroed in on another sailor, Robert Davis. They bring him into an interrogation room. Davis is read his Miranda rights and he agrees to talk. For about an hour and a half, he denies any involvement. But the investigators keep pressing, keep pushing, telling him his story doesn't add up. Finally, feeling the pressure mount, Davis says, "Maybe I should talk to a lawyer." That one word. Maybe. The investigators immediately stopped their questioning about the murder. But they didn't get him a lawyer. Instead, they focused on clarifying his statement. They told him, "We're not going to pursue this unless you say you want a lawyer." They essentially put the ball back in his court. Davis then said, "No, I'm not asking for a lawyer." And the interrogation continued for another hour, at the end of which, he confessed to the murder. His case went all the way to the Supreme Court. His defense argued that the moment he even mentioned a lawyer, questioning should have stopped for good. But the Supreme Court disagreed. In a landmark decision, Justice Sandra Day O'Connor wrote that a suspect must articulate his desire to have counsel present sufficiently clearly that a reasonable police officer in the circumstances would understand the statement to be a request for an attorney. The court said that Davis's statement, "Maybe I should talk to a lawyer," was too ambiguous. A reasonable officer could have interpreted that as Davis just mulling over his options, not actually demanding a lawyer right then and there. The court was worried that if they allowed ambiguous statements to count, it would create a massive gray area. Suspects could just drop hints about lawyers to stop questioning whenever they felt uncomfortable, without truly wanting one, effectively hamstringing police investigations. So they drew a hard, bright line. The request must be clear. "I think I want a lawyer" is not enough. "Do you think I need a lawyer?" is not enough. "Maybe I should talk to a lawyer" is definitely not enough. These are not requests. These are questions. They are musings. And in the cold, hard logic of the law, they are legally meaningless to stop an interrogation. You are essentially giving the police a green light to help you make up your mind. And how do you think they're going to persuade you? They'll say things like, "Look, you can talk to a lawyer, but that's going to make things a lot more complicated. Once lawyers get involved, we can't help you anymore. Right now it's just you and me. We can work this out. Just tell us your side of the story." It's an incredibly effective tactic. They present the lawyer not as your shield, but as a wall that will prevent you from getting a good deal, or from showing that you're cooperative. They are legally allowed to do this because you haven't made an unambiguous request. You left the door open a crack and they will kick it wide open. So what is the bulletproof phrase? What are the magic words that act as a legal full stop? It's not complicated. It's not a secret legal incantation. It's brutally simple and direct. "I want a lawyer." That's it. No maybe, no I think, no should I. Another equally powerful phrase is, "I am invoking my right to remain silent." And a third, which combines them both, "I am invoking my right to an attorney, and I will not answer any questions without my lawyer present." You must say one of these phrases, or a close, clear declarative version of them. "I want to speak to an attorney. Get me a lawyer. I am exercising my right to counsel." And once you say those words, the most important thing you can do next is the hardest thing to do in that situation: shut up. Completely. Do not say another word. The officers are trained for this moment. They know that most people are deeply uncomfortable with silence. They know you have an overwhelming psychological need to explain yourself. They might not ask you about the crime anymore, but they might try to engage you in small talk. So, where are you from? Man, how about that game last night? It's cold in here, isn't it? This isn't them being friendly. This is a technique. They are trying to get you talking again. Because the second you re-engage in conversation, you might accidentally say something incriminating. Or they might hope you'll get frustrated with the silence and reopen the door yourself by saying something like, "Okay, fine. What do you want to know?" If you do that, you have just waived the very right you invoked moments before. The interrogation is back on, and it's perfectly legal. So you say, "I want a lawyer." And then you embrace the silence. You stare at the wall. You count the tiles on the floor. You do not speak. They cannot legally question you further about that crime. The interrogation, for all intents and purposes, must cease. This is the key. It's a binary switch, not a dial. Your rights are either on or off. Ambiguous language leaves the switch in the off position. A clear declarative statement flips it on. But this raises a critical question. You've said the magic words. You've gone silent. The interrogation about that specific crime has stopped. But you're still in that room. You're not free to go. What happens now? What are the police allowed to do? Can they hold you indefinitely? Can they start asking you about a completely different crime? What if they put you in a cell with an informant who starts asking you questions? The act of lawyering up isn't a magic spell that teleports you home. It's the beginning of a whole new phase of the chess match. And the police have a playbook for exactly what to do next. So let's open that playbook. What's the first page the police turn to after you've said the magic words? "I want a lawyer?" The first, and perhaps most insidious, tactic is the one we just hinted at, the jailhouse informant. The legal theory here is a masterpiece of subtle distinction. Your Fifth Amendment right protects you from compelled self-incrimination, and your Sixth Amendment right gives you a lawyer during custodial interrogation by the state. But a casual conversation with a fellow inmate? That's not an official interrogation. He's not a cop. He can't compel you to do anything. You're just two guys shooting the breeze in a tough spot. The problem is that friendly, sympathetic guy who smells like he hasn't showered in 3 days might just be wearing a wire. Or more likely, he's been promised a lighter sentence on his own charges if he can get you to talk. This isn't a hypothetical. The Supreme Court case Illinois v. Perkins dealt with this exact scenario. An undercover officer was placed in a cell with a suspect and started a conversation about planning a prison break. In the course of this con-to-con chat, the suspect confessed to a murder. His lawyers argued this was a violation of his rights. The Supreme Court disagreed. They ruled that since the suspect didn't know he was talking to a cop, the coercive atmosphere of a police interrogation was missing. He was, in their view, speaking freely. Think about the psychology of this. You've just been arrested. Your world is spinning. You're isolated, scared. And you've just made a powerful enemy by refusing to cooperate with the police. Then, you're put in a holding cell with someone who seems to be in the exact same boat. He sighs, shakes his head and says, "Man, they're really trying to pin this thing on me. Said I did a burglary over on Elm Street. It's crazy. What did they get you for?" It is a perfectly disarming question. It's not an interrogation. It's an invitation to commiserate. Your natural human instinct is to connect, to share your story, to find an ally. And in that moment of perceived camaraderie, you might say something. "They think I was involved in that bank job downtown." Or even, "I was there, but I didn't do anything." That's it. That's all they need. Your friendly cellmate will be on the witness stand at your trial, and your own words will be used to convict you. The lesson is brutal. After you ask for a lawyer, the only person you talk to about your case is your lawyer. Full stop. Everyone else is a potential agent of the state. The second play from the book is the war of attrition. The police know that invoking your right to counsel is an act of defiance and strength. So their goal is to wear that strength down. They can't question you anymore, but they can control your environment. This is where the long, agonizing wait begins. They might put you in a small windowless room. The temperature is just a little too cold. The chair is hard plastic. There's a clock on the wall, and every tick feels like an hour. They don't have to be overtly menacing. In fact, it's more effective if they're not. An officer might pop his head in every hour. He won't ask about the case. He'll just say, "You doing okay in here? Need some water? A cup of coffee? Just let me know if you change your mind and want to get this over with." The psychological warfare. They are creating a sense of isolation and hopelessness, while simultaneously offering you a simple, easy way out: just talk. They might leave a file on the table with your name on it, thick with papers you can't read. They might have loud, audible conversations just outside the door about how the other suspect is cutting a deal and telling them everything. It's all designed to make you second-guess your decision. You start thinking, my lawyer isn't here yet. How long is this going to take? Maybe if I just explain my side of the story, I can go home. What if my co-defendant is burying me right now? The moment you crack and say, okay, wait, what kind of deal is he getting? I want to talk. You have just reinitiated contact. The legal shield you raised is now gone by your own hand. The police can start questioning you all over again, and everything you say is fair game. And they can legally wait you out. For a long time, in 2010, the Supreme Court decided Maryland v. Schatzer. They created what's now known as the 14-day rule. If you invoke your right to a lawyer and are then released from custody, say you're let go or you're a prisoner who just goes back to the general population, the police have to wait 14 days. After that 2-week cool-down period, they can come find you, Mirandize you again, and try to start a new interrogation. The court reasoned that 2 weeks is enough time for you to reacclimate to your normal life and consult with friends, family, or a lawyer. So the coercive effects of the previous custody have worn off. It essentially puts an expiration date on your invocation. The third, and one of the most brilliant and dangerous, police tactics is the offense-specific loophole. Your right to counsel is not a blanket protection that covers you for every crime you've ever committed or might be suspected of. It is, in the eyes of the law, offense-specific. This means it only attaches to the specific crime for which you are in custody. Let's paint a picture. You are arrested for an armed robbery that happened last Tuesday. You are taken to the station, you invoke your right to counsel, and the interrogation about the robbery stops. You're feeling secure. You did the right thing. Then, an hour later, 2 different detectives walk into the room. They introduce themselves. They say, "We're not here to talk about that robbery. We understand you've asked for a lawyer on that. We're from a different unit. We want to talk to you about an unsolved homicide from last year." They then read you a fresh set of Miranda Rights. This is a critical moment. You're confused. You think, I have nothing to do with a homicide. I can clear this up easily. And I already asked for a lawyer, so I must be protected, right? Wrong. The Supreme Court case McNeil v. Wisconsin established that because the right to counsel is offense-specific, police are perfectly free to question you about crimes for which you have not yet been charged and have not yet requested a lawyer. This is a devastatingly effective trap. They are banking on the fact that you won't understand this fine legal point. In your attempt to prove your innocence on the homicide, you might create an alibi that accidentally destroys your alibi for the robbery. For instance, you say, "I couldn't have been near that homicide scene last year. I've never even been to that part of town." But the robbery you were arrested for happened in that exact part of town. You've just placed yourself at the scene. Or you might try to show you're a small-time thief, not a killer, saying, "Look, I'm not a murderer. I've done some petty stuff, maybe a robbery here or there. But I'd never hurt anyone." You've just confessed. This tactic exploits the gap between what people think, "I want a lawyer" means, and what it actually means in the cold, hard text of constitutional law. Finally, there's the emergency override switch, the public safety exception. This is another Supreme Court creation from the case of New York v. Quarles. The facts were simple. Police chased a suspect they believed was armed into a supermarket. When they caught him, they found an empty holster. Before reading him his Miranda rights, an officer asked, "Where's the gun?" The suspect pointed to where he'd hidden it. The court ruled that the officer's question and the suspect's answer were admissible in court, even without a Miranda warning. Why? Because there was an immediate threat to public safety, a loaded gun in a public place, that overrode the suspect's Fifth Amendment rights in that moment. So how does this apply after you've lawyered up? Imagine a scenario involving a kidnapping. The police arrest a suspect, and the suspect immediately says, "I want my lawyer." But the police believe the victim is still alive, hidden somewhere and running out of time. They can lean on the public safety exception to continue questioning, framing it not as an interrogation to build a case, but as a rescue mission. They'll say, "Look, forget the charges for a minute. Person's life is on the line. Just tell us where they are." It puts you in an impossible moral position. Do you stick to your rights while someone might be dying, or do you talk? It's the ultimate pressure tactic, using the law itself as a justification to bypass the very protections the law is supposed to provide. The cellmate snitch, the psychological waiting game, the offense-specific end run, the public safety emergency. This is the playbook. It's a series of sophisticated, court-approved strategies designed to counter your one and only move. Invoking your right to counsel doesn't end the game. It just signals that the opening moves are over and the complex, high-stakes middle game is about to begin. These are the moves the police can make. But what about your lawyer? When that call is finally made, what does that lawyer actually do? What are the first critical steps they take to counter this playbook and protect you? The answer isn't what you see on TV. It's a frantic, strategic race against the clock, and it starts the second they pick up the phone. That phone call is a triage session, a high-stakes intelligence-gathering mission compressed into 60 seconds of pure, unadulterated crisis management. The lawyer isn't just asking what happened. They are surgically extracting the most critical data points needed to build an instantaneous defense. First question: where exactly are you? Not the city, not the neighborhood. The precinct. The holding facility. The specific room if you know it. This tells the lawyer which jurisdiction they're in, which set of prosecutors they'll be facing, and even which judges might be on the bench. It's the first pin on the strategic map. Second question: who are you with? Are you with uniformed officers? Is it a detective? Do you have their name? Their badge number? Are they from a specific unit, homicide, narcotics, special victims? This identifies the adversary. A patrol officer making a routine arrest operates differently than a seasoned homicide detective who has been trained for years in the art of psychological interrogation. Knowing the player tells the lawyer the game they're playing. Third and most important question: have you said anything to them about what happened? This is the damage assessment. The lawyer needs to know if the police playbook has already worked. Did you try to explain yourself? Did you try to be helpful? Did you deny something specific? Every word you've uttered is a potential brick in the wall. The prosecution will build around you. The lawyer needs to know how many bricks they already have. And then comes the instruction. It is not a suggestion. It is a command delivered with the force of a legal shield being slammed into place. Stop talking. Now, do not say another word to anyone about anything. Don't talk to the police. Don't talk to the person in the cell next to you. Don't explain. Don't apologize. Don't ask questions. Nod your head if you understand me. I am on my way. The moment they hang up, the lawyer becomes a whirlwind of activity, and none of it involves jumping into a car just yet. The race has already begun. Their first call is likely to the police station where you're being held. They'll ask for the desk sergeant or the watch commander. They'll announce who they are and who they represent. Their goal is twofold. First, to put the entire police department on official notice that you have legal representation. This is a formal verbal planting of the flag. Legally, it makes it much more difficult, and much more dangerous for their case, for police to continue trying to question you. Second, they are fishing for the magic words, the charge. What are you actually being held for? You might think you were arrested for one thing, but the police might be building a case for something entirely different and far more serious. They are often deliberately vague with suspects. But with a lawyer, they are speaking to an officer of the court. While they might still be cagey, the lawyer knows the specific language to use, the specific statutes to reference to pry that information loose. Is my client under arrest for a violation of Penal Code Section 459? Is a very different question than what's he in for? While they are doing this, another part of their brain is already running scenarios. If the charge is a DUI, they're thinking about the timeline for the chemical test. They're thinking about the calibration logs for the breathalyzer machine, logs they will demand to see later. They're thinking about the dashcam and bodycam footage of the field sobriety test. If the charge is assault, they're thinking about witnesses. They're thinking about surveillance cameras in the area. They might even be dispatching an investigator from their office, right then in that moment, to go to the scene and start canvassing for doorbell cameras before the footage is erased. They are working to preserve evidence that the police might not be interested in, especially if it helps you. This is the frantic, unseen battle that happens in the first 30 minutes. It's about stopping the state from getting a head start. When the lawyer finally walks through the doors of that police station, the entire atmosphere shifts. The power dynamic, which was 1,000 to 1 against you, is instantly rebalanced. They are not there to be friendly. They are not there to work things out. They are a walking, talking embodiment of the Sixth Amendment. They will approach the desk, identify themselves, and state with unshakable authority, "I am here to see my client Jane Doe. Please inform the detective in charge that all questioning is to cease immediately." I will be speaking with my client in a private room now. That last part is crucial. The right to confer with your counsel in private is a cornerstone of the legal system. This isn't a chat in the corner of the busy squad room. This is a confidential, legally protected meeting behind a closed door. This is the creation of a sanctuary. Inside that room, for the first time since this ordeal began, you can speak without fear. This is where attorney-client privilege is born. It is one of the oldest and most sacred principles in law. It means that what you say to your lawyer in confidence stays with your lawyer. They cannot be forced to testify against you. They cannot reveal your secrets. This privilege is so absolute that it allows a lawyer to do their most important job. Learn the unvarnished, complete, and sometimes ugly truth. Because that is what they need. They don't want the story you think sounds best. They don't want the version that makes you look good. They need the raw data. They will grill you more intensely than the police ever could, but for a different reason. The police are looking for admissions of guilt. Your lawyer is looking for facts, any facts that can be used to protect you. They'll ask you to start from the beginning. Not from the moment of the arrest, but from hours or even days before. What did you do? Who were you with? What did you say? What did they say? They are listening for constitutional violations. Did the police have a reason to stop you? Did they have a warrant to search? Did they read you your Miranda rights before you said something incriminating? They are deconstructing the state's narrative before it's even been fully written. And with every answer you give, they are formulating the next move. Once they have a baseline understanding of the facts from your perspective, the next phase of the counterplaybook begins. Their first official act is often to serve the police and the prosecutor's office with a formal letter of representation and, critically, a preservation demand. This isn't a polite request. It's a legal order. It says, in no uncertain terms, you are to preserve any and all evidence related to this case. All video and audio recordings, all officer notes, all dispatch logs, all text messages and emails between involved personnel. If you destroy, alter, or lose any of this evidence from this moment forward, we will argue in court that it was because it was favorable to my client, and we will ask for sanctions, up to and including dismissal of the case. This single document stops the accidental deletion of an inconvenient body cam file. It prevents an officer from losing their handwritten notes that might contradict their final report. It freezes the battlefield exactly as it is, so the lawyer can then use the discovery process to see everything the state has. Finally, the lawyer takes back control of your voice. They will inform the lead detective that their client will not be making any further statements. Period. The door to interrogation is not just closed. It is locked, bolted, and barricaded. Any attempt by the police to talk to you again, a friendly just wanted to clear one thing up, is now a serious ethical and legal violation that could jeopardize their entire case. The lawyer has become your sole spokesperson. The police wanted you isolated, tired, and talking. The lawyer ensures you are supported, protected, and silent. This isn't just about preventing a confession. It's about seizing control of the flow of information. From this point on, the state doesn't get to hear your story from your mouth. They will only hear it, if at all, on the terms your lawyer sets, in a time and place of your lawyer's choosing, the courtroom. The arrival of your lawyer doesn't just end the interrogation. It marks the end of the investigation phase and the beginning of the legal war. And in that war, you are no longer a lone soldier. You now have a general. This general, your lawyer, doesn't just walk in and ask for a cup of coffee. Their arrival triggers a cascade of legal maneuvers, a series of strategic moves designed to seize control of the narrative and the process. The first thing that happens is the most important. They get you alone. The lead detective might say, "You can have 5 minutes in interview room 3. And in that moment, the entire power dynamic of your situation inverts. You walk into that small, sterile room, the door clicks shut, and for the first time in hours or maybe even days, you are in a protected space. This is the inner sanctum, the cone of silence, created by one of the most sacred principles in the American legal system: attorney-client privilege. This isn't just a professional courtesy. It's a nearly impenetrable shield. It means that anything you say to your lawyer, and anything they say to you, is confidential. Forever. It cannot be used against you. Police cannot bug the room. The prosecutor cannot subpoena your lawyer and force them to testify about your conversation. This privilege is the bedrock upon which your entire defense will be built. It allows you to be completely, brutally honest. And you must be. Your lawyer isn't there to judge you. They are there to defend you. They need to know everything, the good, the bad, and the ugly, because they cannot defend you against a secret. A hidden fact is a landmine waiting to go off in the middle of a trial, and your lawyer's job is to sweep the field and defuse every single one. So their first question won't be, "Did you do it?" It will be, "What did you say to them?" They need to perform immediate triage. They need to assess the damage. Did you talk? Did you admit to being at the scene? Did you try to give an alibi that can be easily disproven? Did you consent to a search of your car or your home? Did you sign any forms? They are piecing together the events from the moment of your first contact with law enforcement, looking for mistakes the police made, and mistakes that you made. Based on this damage report, the lawyer's next instruction will be simple, direct, and non-negotiable. It will be some variation of, "From this second forward, you do not speak to anyone about this case except for me. Not the police. Not your cellmate. Not your family on the recorded jail phone line. You say nothing. The answer to every question from anyone is, 'I'm sorry, my lawyer has advised me not to discuss the case.' That's it. You are no longer the source of information. You are now a black hole. This is the first wall of the fortress your lawyer is building around you. They have just severed the police's direct line of communication. From now on, if the police or the prosecutor want something from you, a statement, a sample, any form of cooperation, they have to go through your lawyer. Your attorney becomes the gatekeeper, the switchboard operator, the sole guardian of all information flowing in and out. This is a monumental shift. You are no longer reacting to the investigation. Your lawyer is now forcing the investigation to react to them. With the information flow now under control, your lawyer goes on the offensive. They don't wait for the prosecutor to make the first move. They launch their own campaign, and it starts with a powerful legal weapon called a motion for discovery. Think of this as a formal, legally binding demand to the prosecutor that says, "Show me your cards. Show me everything." The state is legally obligated to turn over all the evidence it has gathered against you. This isn't just the stuff they plan to use in court. It's everything. Every single police report, every witness statement, all photos and videos from the crime scene, the full, unedited body camera and dashcam footage, all forensic and lab results, a list of all witnesses they plan to call, and, most critically, they must turn over any exculpatory evidence, that is, any evidence that tends to show you are innocent. This is a constitutional requirement, and it is the key to leveling the playing field. Before discovery, you're fighting a ghost. You're swinging in the dark at accusations you can't see. After discovery, the lights come on. Your lawyer will sit down with a mountain of paperwork, videos, and reports, and they will go through it line by line, frame by frame. They are looking for inconsistencies. They're looking for contradictions in witness statements. They're looking for sloppy police work. They're looking for the officer whose body cam footage doesn't quite match his written report. They are searching for the single thread that, when pulled, can unravel the entire tapestry of the prosecution's case. While they are analyzing the state's evidence, they are also looking for ways to attack it. This leads to another set of powerful tools. Pretrial motions, specifically the motion to suppress. A motion to suppress is your lawyer telling the judge, "The government broke the rules to get this evidence, and you cannot allow them to use it." For example, let's say the police found something incriminating in the trunk of your car. If your lawyer can prove that the police did not have probable cause or a warrant to search your trunk, that the search was a violation of your Fourth Amendment rights, they can file a motion to suppress that evidence. If the judge agrees, that evidence is gone. It's as if it never existed. The jury will never hear about it. The prosecutor cannot mention it. It has been legally vaporized. The same goes for a confession. If your lawyer can demonstrate that you were coerced, that you were not properly read your Miranda rights, or that you invoked your right to a lawyer and the police kept questioning you anyway, they can file a motion to suppress your entire statement. This can be devastating to the prosecution. Often, the state's entire case is built on a key piece of evidence or a confession. A successful motion to suppress isn't just chipping away at their case. It's like taking a sledgehammer to its very foundation. But before these major battles over evidence, there is often a much more immediate and crucial fight: the bail hearing. This is usually the first time you will see a courtroom, and it is the first real test for your lawyer. The purpose of bail is not to punish you. You are, after all, presumed innocent. The purpose is simply to ensure you return for your future court dates. You'll be brought into the courtroom, and the prosecutor will stand up and paint the worst possible picture of you. They will read from the police report, emphasizing the most damning details. They will argue that you are a danger to the community, that the evidence against you is overwhelming, and that you are a flight risk. meaning if the court lets you out, you'll disappear. They will ask the judge to set a very high bail amount, an amount they know you and your family likely cannot afford. Then it's your lawyer's turn, and this is where their role as your advocate truly begins. They will stand up and present a completely different picture. They won't be talking about the crime. They'll be talking about you. They will humanize you. They will tell the judge that you have a steady job, that you support your family. They'll point out your mother or your spouse sitting in the courtroom. They will emphasize your ties to the community, that you've lived in the same town your whole life, that you volunteer at your church, that you have no prior record of failing to appear in court. Their job is to convince the judge that you are not a monster or a flight risk, but a citizen with roots, a person who can be trusted to return to court to face the charges. They will argue for a reasonable bail, or even for you to be released on your own recognizance, which means you are released on your word alone. The outcome of this single hearing is monumental. Being able to fight your case from home, instead of from a jail cell, is a game changer. It means you can continue to work and earn a living. It means you can meet with your lawyer in their office, not in a jailhouse visiting room. It means you can help gather evidence, contact potential witnesses, and participate actively in your own defense. Fighting a case while incarcerated is like trying to box with one arm tied behind your back. Winning a reasonable bail is your lawyer untying that arm, giving you a fighting chance from the very first round. It's the first tangible victory in a war that has only just begun. But that victory, as crucial as it is, simply gets you out of the cage. It doesn't win the war. Now, the real intellectual combat begins. This is the part of the legal process that television and movies almost completely ignore, because it isn't flashy. It's a brutal, painstaking, and often tedious grind. It's the phase where cases are truly won or lost, long before a jury ever hears an opening statement. This is the deep strategic work of discovery, investigation, and motions. This is where your lawyer stops being just a defender and becomes a hunter. The first step is called discovery. The name sounds simple, but its implications are profound. In the American system, you are not supposed to be ambushed at trial. A prosecutor can't just pull a surprise witness out of a hat. They are legally, constitutionally, and ethically obligated to turn over their evidence to your defense attorney. This includes police reports, witness statements, lab results, photographs, body camera footage, everything they plan to use to try and convict you. This is the government being forced by law to show its hand. Your lawyer receives this mountain of information, and the first, most critical job begins: analyzing the case the state thinks it has against you. But it goes so much deeper than that. There's a sacred principle in American law, enshrined by the Supreme Court case Brady v. Maryland. It's called the Brady Rule, and it is a cornerstone of a fair trial. The Brady Rule states that prosecutors must turn over not just the evidence that makes you look guilty, but also any evidence they have that could prove you are innocent. Let that sink in. The very people trying to put you in prison have a constitutional duty to give your lawyer the tools to set you free. This is called exculpatory evidence. What does that look like in the real world? It could be a police report where the only eyewitness initially described the suspect as being 6 inches taller than you. It could be a lab test that came back inconclusive. It could be information that their star witness is also a paid informant in another case, giving them a motive to lie for the government. It could be a security camera video the police collected that they claim shows nothing, but when your lawyer's expert enhances it, it clearly shows a different person entirely. This is Brady material, and a prosecutor hiding this kind of evidence isn't just a legal misstep. It's a catastrophic violation of your rights that can get a conviction overturned, and in some cases, get the prosecutor disbarred. A great lawyer doesn't just ask for this material. They hunt for it. They know what to look for, what questions to ask, and how to spot the suspicious gaps in the state's file that might indicate something is being hidden. This leads to the next critical function of your lawyer. They become the lead investigator on a case the police believe is already closed. A good defense attorney never, ever takes the police investigation at face value. They operate from a position of professional skepticism. They understand that police can be overworked, they can make mistakes, and they can suffer from tunnel vision, focusing on the first likely suspect and ignoring any evidence that points away from them. So, your lawyer, often with a private investigator, goes back to the beginning. They go to the scene of the crime. They re-interview all the witnesses the police spoke to, because people will often say things to a defense investigator that they were too intimidated to say to a uniformed officer. More importantly, they find and interview the witnesses the police never even bothered with. The neighbor who saw a different car speeding away. The clerk at the convenience store down the street who saw someone matching a different description. They pull cell phone tower data, GPS records, social media posts, and financial transactions. They are building a competing narrative, an alternative theory of the case grounded not in speculation, but in facts the police either missed or ignored. They are building the story of your innocence, piece by painstaking piece. While this investigation is happening, your lawyer is also using a powerful tool called a deposition. A deposition is a formal, sworn interview of a witness, conducted under oath with a court reporter transcribing every single word. This is your lawyer's chance to question the prosecution's witnesses before the trial. It's a dress rehearsal for cross-examination, and it is absolutely vital. This is where your lawyer can lock a witness into their story. If a police officer says in a deposition that he had a clear, unobstructed view from 100 yards away at night, and later at trial he changes that to 50 yards, your lawyer can impeach his credibility with his own sworn words. "Officer, isn't it true that on May 15th, you swore under oath that the distance was 100 yards? It destroys the witness's credibility in the eyes of the jury. Depositions are also used to uncover information and test the strength of a witness. How do they hold up under pressure? Do their answers seem rehearsed? Do the details of their story fall apart when questioned? This is where a shaky witness can be exposed, sometimes so badly that the prosecutor will realize their case is much weaker than they thought. All of this, the discovery, the investigation, the depositions, is generating ammunition. And that ammunition is loaded into one of the most powerful weapons in a defense attorney's arsenal: the pretrial motion. A motion is a formal request asking the judge to make a ruling on a legal issue. And some motions can cripple or even completely destroy the prosecution's case before it ever gets off the ground. The most famous of these is the motion to suppress evidence. This is where your lawyer argues that the police violated your constitutional rights, usually your Fourth Amendment right against unreasonable searches and seizures. For example, let's say the police pulled you over for a broken taillight, then claimed they smelled marijuana, a common pretext, and searched your entire car without a warrant or your consent, finding something illegal in the trunk. Your lawyer would file a motion to suppress. They would argue that the police had no probable cause to search your trunk. The judge would hold a hearing, listen to testimony from the officers and arguments from your lawyer, and make a decision. If the judge agrees that the search was illegal, the evidence found in that trunk is suppressed. It's excluded. It's as if it never existed. The prosecutor is forbidden from mentioning it, and the jury will never know it was there. This is the fruit of the poisonous tree doctrine. The illegal police action is the poisonous tree, and the evidence is the fruit. You can't use illegally obtained evidence in court. For many cases, especially drug or weapon possession charges, a successful motion to suppress is a kill shot. Without the evidence, the government has no case, and the charges are often dismissed. This is the hidden war. It's a war fought in paper, in law libraries, and in quiet hearing rooms. It's about using the Constitution as both a shield and a sword. It's about taking the case that the state has built and systematically dismantling it, brick by brick, by showing that their evidence is unreliable, their witnesses are not credible, or their methods were unconstitutional. Each successful motion is another crack in their foundation, until the entire structure is on the verge of collapse. And when a prosecutor sees their case, their meticulously constructed edifice of guilt, start to crumble, they are faced with a terrifying choice. They can gamble, take this weakened case to trial, and risk losing in front of a jury, a public defeat that damages their record and wastes taxpayer money. Or they can offer a deal. This is where the vast, overwhelming majority of the American legal system actually lives. Not in the dramatic courtroom showdowns you see on TV, but in quiet rooms, in hushed hallway conversations, and intense, calculated negotiations. This is the world of the plea bargain. And it is, without a doubt, the most misunderstood and strategically critical phase of what it means to lawyer up. To the public, a plea bargain often sounds like a failure. It sounds like someone getting away with it. But from inside the system, it's not a failure. It's a battlefield of its own, governed by leverage, risk, and cold, hard mathematics. And every single action your lawyer has taken up to this point, invoking your right to silence, scrutinizing the discovery, filing those motions to suppress, was not just about preparing for trial. It was about gathering chips for this high-stakes poker game. Every piece of evidence thrown out is a handful of chips. Every inconsistent witness statement is a powerful card in their hand. Every constitutional violation they uncover is like being dealt a royal flush. The prosecutor isn't just a seeker of justice. They are a bureaucrat managing an impossible caseload. They have dozens, sometimes hundreds of other cases on their desk. They are under immense pressure from their superiors to close cases and secure convictions. A trial is a massive drain on their most precious resources, time and money. It can take days or weeks, involve pulling police officers off the street to testify, and require extensive preparation. And if their case is weak, if your lawyer has successfully chipped away at it, the risk of losing is high. A loss isn't just a mark on their record. It's a colossal waste of resources that could have been used to prosecute 10 other cases. So they come to the table. The first offer might be insulting. It's a test. They might offer to drop one of 5 charges if you plead guilty to the other 4. Your lawyer, armed with the weaknesses they've exposed, will likely laugh it off. They'll counter, not with an offer, but with a threat. They'll say, "We're not taking any deal that involves a felony. We'll see you at trial." This isn't just bravado. It's a calculated message. We know your case is weak. We know your key witness is unreliable. We know the search was questionable. We are not afraid of a jury. Suddenly the dynamic shifts. The prosecutor has to reevaluate. Is a conviction on a lesser charge, a misdemeanor perhaps, better than the very real possibility of a complete acquittal? Is it better to get a guaranteed win, no matter how small, than to risk a total loss? The negotiations go back and forth. The offers get better. The charges are reduced from felonies to misdemeanors. The proposed sentences shrink from years in prison to months of probation. This is the art of negotiation, where your lawyer's skill, reputation, and the strength of the case they've built through pre-trial work dictate the outcome of your life. But there's a darker side to this process, a coercive force that hangs over every single negotiation. It's a concept known as the trial penalty, and it is one of the most terrifying realities of the American justice system. The system is built to discourage you from exercising your constitutional right to a trial. It does this by making the potential punishment for losing at trial so catastrophically severe that it becomes almost irrational to take the risk. Let me paint you a picture. Imagine you're charged with a crime that carries a potential sentence of 10 to 15 years in prison. The prosecutor offers you a plea deal. Plead guilty, and we'll recommend a sentence of just 2 years. On the surface, that might sound like a good deal. But what it really is a threat. The unspoken message is, if you dare to make us go to trial, if you dare to take up our time and resources and you lose, we will ask the judge to give you the absolute maximum. We will bury you. That difference, the 2 years they offer versus the 15 years you risk, that is the trial penalty. It's a powerful weapon of coercion designed to secure a guilty plea and clear a case from the docket. Now, here's the question that haunts the entire system, the question that should keep you up at night. What if you're innocent? Why on earth would an innocent person ever plead guilty to a crime they did not commit? The trial penalty is the answer. Imagine it's you. You are factually 100% innocent, but you've been charged with a serious felony. The evidence against you is flimsy. It's based on the testimony of a single questionable eyewitness. Your lawyer has done a brilliant job. They've shown the witness has a motive to lie, that their memory is flawed. They've filed motions and created serious doubt. But in the American legal system, there is no such thing as a guaranteed win. A jury is 12 random human beings. They can be swayed by emotion. They might find the witness compelling despite the flaws. They might just get it wrong. Your lawyer, the one who has been fighting for you, has to sit you down for the hardest conversation of your life. They'll say, "Look, I believe you are innocent. I believe our case is strong. I think we have an 80% chance of winning at trial." An 80% chance sounds great, right? But then they continue. But there is a 20% chance we lose. And if we lose because of the mandatory minimums for this charge, you are going to prison for 10 years. 10 years. Your kids will grow up without you. You'll lose your house, your career, everything. You feel the blood drain from your face. Then they deliver the final blow. The prosecutor just called. They know their case is weak. They're scared of trial. They've made their final offer. If you plead guilty to a lesser charge, a misdemeanor, you'll get 1 year of probation. No jail time. You can go home to your family today. But you will have a criminal record. And you will have to stand up in court and say you did something you didn't do. What do? Do you risk a 20% chance of losing a decade of your life to fight for the 80% chance of vindication? Or do you take the guaranteed deal that lets you go home, but forces you to live with a lie and a criminal record for the rest of your life? Do you gamble with your future? Or do you swallow the poison to save your life? This is not a hypothetical. This is a choice that thousands of people, many of them innocent, are forced to make every single day in America. This is why over 95% of all criminal convictions in the United States come not from a jury trial, but from a guilty plea. The system is designed to produce them. In this moment, your lawyer's role transforms again. They are no longer just a warrior or a negotiator. They become your most important counselor. They cannot make the decision for you. They can only lay out the cold, brutal odds. They can tell you about the judge, the prosecutor, the tendencies of juries in that county. They can give you their best, most honest assessment of the risks. But the final decision, the one that will define the entire course of your future, is yours and yours alone. It is a moment of profound and terrifying isolation. And for the small fraction of defendants who, faced with this impossible choice, look the trial penalty in the eye and refuse to blink, for those who bet everything on their innocence, who refuse to admit to something they didn't do, who decide to roll the dice and hold the state to its burden of proof, then, and only then, does the real drama begin. The negotiations are over. The deals are off the table. The next stop is a room with 12 strangers in a box, where your life will be debated, judged, and ultimately decided. The courtroom doors are about to swing open. The air in a courtroom is unlike anything else. It's thick with a mixture of stale coffee, old wood, and pure unadulterated tension. It's a place of forced silence, where a cough can sound like a gunshot. As the defendant, you sit at a heavy table next to your lawyer, the one person in the entire room who is unequivocally on your side. Across the aisle sits the prosecutor, the champion of the state, representing the full weight and power of the government. In the center, elevated above everyone, is the judge, the referee in this fight, draped in a black robe that signifies impartiality. But the most important people in the room aren't the ones with law degrees. They're the ordinary citizens being called, one by one, to sit in the jury box. This is where the battle for your freedom truly begins, with jury selection. This process is called voir dire, a French term meaning to speak the truth. But in practice, it's a high-stakes game of psychology. The goal isn't really to find 12 unbiased people. That's a myth. The goal for each side is to eliminate the people they believe will be biased against them. The prosecutor and your lawyer will question a pool of potential jurors, probing their backgrounds, their beliefs, their life experiences. The prosecutor might ask, "Do you believe police officers are generally trustworthy?" Your lawyer might ask, "Have you ever felt that a large organization treated you unfairly?" They are looking for subtle clues, for hidden prejudices. Each side gets a certain number of peremptory challenges, which means they can dismiss a juror for almost any reason at all, a gut feeling without having to explain why. They can't do it for a discriminatory reason, like race or gender, but it's a powerful tool. Your lawyer isn't just a legal expert anymore. They are a casting director, trying to assemble an audience that will be receptive to your story. Once the jury is sworn in, the trial begins with opening statements. This is the movie trailer for the case. The prosecutor stands up first. They walk towards the jury, make eye contact, and they tell a story. It's a confident, clear narrative of what they believe you did. They'll say, "The evidence will show," and "the testimony will prove." They are making a promise to the jury. By the end of this trial, they'll declare, "You will have no choice but to find the defendant guilty beyond a reasonable doubt." It's powerful, it's compelling, and it's designed to frame the entire trial in a narrative of your guilt. Then it's your lawyer's turn. They stand up to deliver their opening statement. They might offer a counter-narrative, an alternative story of what happened, or they might simply go on the defensive, reminding the jury of the most important principle in American justice, the presumption of innocence. Your lawyer will look at the jury and say, "The prosecutor has told you a story, but a story is not evidence. They have made promises about what they will prove. Your job is to hold them to that promise. Your job is to listen for the facts, but more importantly, to listen for what's missing. Listen for the doubt." This first impression is everything. It sets the stage for the entire drama to unfold. After opening statements, the prosecution begins its case in chief. This is where they try to fulfill the promise they made. They will call witnesses to the stand one by one to build their case against you. With each of their own witnesses, the prosecutor conducts a direct examination. The questions are open-ended. What did you see on the night of June 5th? Can you describe the person you saw? Then what happened? They are letting their witness tell the story they want the jury to hear. But after the prosecutor is done with each witness, your lawyer gets to stand up and cross-examine them. This is the moment you see in movies, and it is every bit as dramatic in real life. Cross-examination is the engine of truth-finding. Your lawyer's job is to test the witness's story, to probe for weaknesses, inconsistencies, and biases. The questions are pointed, leading, and designed to control the witness. You were 100 feet away, correct? And it was dark, wasn't it? You weren't wearing your prescription glasses at the time, were you? The goal is to poke holes in the prosecution's narrative, to show the jury that the witness's memory is flawed, their perception is unreliable, or their motives are questionable. This is a verbal chess match, and your lawyer is fighting to protect you. During this process, you'll hear lawyers shout "objection," followed by legal terms like hearsay or speculation. These aren't just for drama. Your lawyer is acting as a gatekeeper, enforcing the rules of evidence to prevent improper, unreliable, or prejudicial information from ever reaching the jury's ears. Once the prosecution has presented all of its witnesses and evidence, they will stand and say the words, "The government rests." A silence hangs in the air. Now the burden of proof has been on them. Legally, your lawyer doesn't have to do anything. You don't have to prove your innocence. The defense can simply make a motion to dismiss the case, arguing the state failed to prove its claims. But usually, the defense will present its own case. They might call alibi witnesses, or their own experts to challenge the prosecution's evidence. And this leads to the single most difficult and dangerous decision in any criminal trial: whether you, the defendant, should take the stand in your own defense. The jury is desperate to hear from you. They want to look you in the eye and hear your side of the story. It's your one chance to speak directly to them, but it is a monumental risk. If you testify, you are subjected to the same brutal cross-examination as every other witness. The prosecutor, who has spent months, maybe years, preparing to convict you, will get to question you directly. They will try to twist your words, to trip you up on minor details, to make you angry or nervous, to paint you as a liar in front of the very people who hold your life in their hands. Your past convictions, your character, things that were previously off-limits, can sometimes become fair game. Deciding whether to testify is a terrifying gamble, and it's a decision you and your lawyer must make together, weighing the potential reward against the catastrophic risk. After the defense presents its case, or chooses not to, both sides rest. Now it's time for closing arguments. This is the grand finale. The lawyers will once again approach the jury, but this time, they are not just presenting a roadmap. They are arguing, persuading, and pleading. They will summarize the evidence that was presented, weaving together the testimony and exhibits into a final cohesive story. The prosecutor will argue that the story proves guilt beyond a reasonable doubt. Your lawyer will argue that the story is full of holes, contradictions, and most importantly, reasonable doubt. This is their last chance to speak to the jury, their last chance to frame the narrative. It's often the most passionate and emotional part of the trial. Finally, the judge reads the jury instructions. This is a long, complex set of legal rules that the jury must follow in their deliberations. The judge explains the elements of the crime, the definition of reasonable doubt, and the principle of the presumption of innocence. Then, the bailiff escorts the 12 jurors out of the courtroom and into a small private room. The door closes, and the waiting begins. In that deliberation room, 12 strangers will debate your fate. They will argue, they will reason, they will cry. They will sift through every piece of evidence, every word of testimony, every doubt planted, and every promise made. For you sitting in the courtroom, the silence is deafening. Hours can feel like days. Every sound from the hallway makes your heart leap into your throat. Then the moment comes. There's a knock on the door. The jury has reached a verdict. They file back into the jury box, their faces unreadable stone. They will not look at you. The foreman hands a slip of paper to the bailiff, who gives it to the judge. The judge reads it, and their face betrays no emotion. They hand it back. The courtroom is utterly still. The clerk asks the foreman to stand. On the charge of the crime, how do you find the defendant? And the foreman speaks one of two words: guilty or not guilty. Two words that will change the course of your life forever. From that first moment of contact with law enforcement, through the interrogation room, the booking process, the arraignment, the discovery, the plea negotiations, and the trial, we've walked through the entire brutal, complex machinery of the American legal system. And now we come back to the original question: What does lawyer up really mean? It does not mean you're guilty. It does not mean you're hiding something. It means you understand the reality of the system. The system is adversarial by design. It is a fight. The police and the prosecutor are on one side. Their objective, their job, is to build a case against you and secure a conviction. They are not your guides, your confessors, or your friends. They are your opponents. Lawyering up means you are evening the odds. It means you are bringing your own professional fighter into the ring. Someone who knows the rules, who speaks the language, who can see the traps you can't. Someone whose entire professional and ethical duty is to one person and one person alone. You. Invoking your right to remain silent and your right to an attorney isn't an act of defiance. It's an act of profound intelligence. It is activating the shield the Constitution handed you for this exact moment, to protect you from the overwhelming power of the state. It is the single most important decision you can make. Because when you are facing the fight of your life, the one thing lawyering up guarantees is that you will not have to fight it alone.